We'll also be recording today's session, and we're so glad that all of you could join us. My name is Christie Edwards, and I'm joining you actually wearing two hats today, both as a co-chair of the American Society of International Law's annual meeting, and also as the deputy head of the Tolerance and Non-Discrimination Department at the OSCE's Office for Democratic Institutions and Human Rights. So for those of you who aren't familiar with the OSCE or with ODIHR, I'll give you just a very brief introduction. The Organization for Security and Cooperation in Europe is the world's largest regional security organization. And with 57 participating states in North America, Europe, and Asia, the OSCE is a forum for political dialogue on a wide range of security issues. And we use a comprehensive approach to security that encompasses three key dimensions, including political, military, economic and environmental, and human dimensions. So the Office of Democratic Institutions and Human Rights, or ODIHR, provides support, assistance, and expertise to governments and civil society to develop and sustain democratic institutions, the rule of law, human rights, and tolerance and non-discrimination. So my department, the Tolerance and Non-Discrimination Department, we've been doing this by gathering and publishing information on hate crimes and hate incidents from all of the participating states. And we advise governments, train prosecutors and police, organize workshops and coalition building events and consultative meetings with civil society. And we also produce a large number of educational and awareness raising tools on addressing intolerance and discrimination. So for today, we've invited a huge group of, or not huge, but a number of really incredible international experts to discuss how digital technology is not only a huge opportunity to communicate across countries and cultures, but it also unfortunately has the ability to spread disinformation, hatred, and incitement to violence. And since the outbreak of the COVID-19 pandemic, we've seen hatred spreading as minority and marginalized communities have found themselves scapegoated and in some cases even becoming victims of targeted violence. And this spread has been sometimes fueled by digital technologies, which make it easier and faster to disseminate conspiracy theories that have been in circulation for many, many years. Human rights are increasingly used to restrict one another rather than advancing each other as part of a human rights framework. And the lack of an international legal definition of hate speech, the coded and contextual nature of hate speech, and the vast amounts of user-generated content and the diversity of content in terms of form and language really do complicate the challenge of balancing the right to the freedom of expression with the need to protect against the advocacy of hate that amounts to incitement to discrimination, hostility, or violence. So for our conversation today, I'll now turn things over to our moderator, Joanna Szymanska, who is the Senior Program Officer at Article 19, and she will introduce the rest of the panel. So Joanna, the floor is yours.
Thank you, Christy, very much. Good afternoon or good evening, everyone, depending where you are. Just before starting, I wanted to say that Article 19 as a global freedom of expression organization consistently calls for an explicit recognition of the relationship between the rights of freedom to expression, non-discrimination, and equality as positive and mutually reinforcing rather than contentious. It is under this framework that international human rights law provides sufficient guidance to identify when limitations to the freedom of expression are required and how to adequately uphold the protection of each respective right. And I think that recently we have more and more discussions in this debate around these topics, whether private companies should be the ones who decide which content can be made available and shared among millions of people and which cannot. Do they have an obligation to suspend content that constitutes incitement to violence when there is risk of damage to people or property? And if so, should they decide when this is the case and based on which parameters? Is there a robust system in place for this kind of moderation? Do platforms apply their policies evenly around the world? We will not protect free speech, democracies, or counter the toxic polarization and violence we have seen develop in various contexts in the last few years unless we develop a structural response. We need procedures based on international human rights standards. And so there are so many questions to answer, and while none of these questions are new, Civil society, academics, decision makers, regulators, and the platforms themselves have been struggling to define answers to them for years. Therefore, I'm very excited about this discussion, and I'm very happy to introduce our excellent speakers today, with whom we'll discuss these challenges and issues in the more detail and hear their perspective. So we have today Karoline Fernandez de la Hoz Zeitler, Director of the Spanish Center for Racism and Xenophobia at the Ministry of Employment and Social Security, National Point of Contact on Hate Crime at the Government of Spain. We have Louisa Klingvall, Team Leader at the European Commission Directorate General Justice and Consumers Unit for Fundamental Rights Policy. We have Ian Levine, Senior Human Rights Advisor from Facebook, and Emerson J. Sykes, Staff Attorney, Speech Privacy and Technology Project from American Civil Liberties Union. So I'm very happy to kick off with the discussion. Ian, I will start with you. Because Facebook adopted its first ever human rights policy just very recently. So perhaps you could tell us a bit more about it, and what difference does the policy make, and how will it contribute to the challenge of protecting freedom of expression while addressing hate speech?
Thanks, Joanna. It's very good to be here. Thanks for those who've invited me and given me the chance to be on a panel with such interesting people. So, as Joanna said, I'm a human rights advisor at Facebook. I joined Facebook last year, having spent most of my working life within the NGO human rights community. Because as Joanna, as you explained in your introduction, I mean, we really are living in an age where the digital environment is such a consequential place for human rights. It's increasingly the place where we exercise our rights to freedom of expression, to freedom of association, to access to information, to health, to education, and so many other things. But of course, it's also a place where our rights are violated through hate speech and violence and incitement and issues around violations of the right to privacy and so much else. And with the rapid growth of the social media platforms, their scale, their scope, their speed, the challenges are enormous for more traditional kind of legal-based human rights processes, mechanisms, and standards. So in that context, we have come to develop our human rights policy, with a very strong recognition that Facebook and the social media platforms have often been justifiably criticized for their failure to put human rights standards front and center of policy development and the ways in which we operate, in the context of growing influence over political discourse and the way people interact around the world. We recognize calls from many actors, NGOs, governments, UN and others, that the protection of human rights on the internet and in the digital environment requires a smart mix of self-regulation as well as government regulation that is human rights friendly. And in developing our human rights policy, we have sought to clarify our commitment to the UN Guiding Principles on Business and Human Rights, which establish the human rights responsibilities of companies to respect human rights. We have sought to assert our commitment to the critical human rights standards that protect freedom of expression, the Universal Declaration of Human Rights, the ICCPR, Articles 19 and 20 obviously being central to this debate. But at the same time, we are calling attention to our commitment to those treaties and conventions which protect particular groups from discrimination. The Convention on the Elimination of Racial Discrimination, CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, the Child Rights Convention, and the Convention on the Rights of People with Disabilities, because we recognize that there are certain groups, usually disadvantaged minorities, historically oppressed groups, who suffer more incitement to violence, bullying, harassment, and hate speech on the platform. And we need to make it clear our commitment to address those factors. In the policy, so we not only seek to set out our commitments to international human rights standards across all that the company does, but to set out how we intend to live up to that commitment. And in the policy, we talk about due diligence, and particularly announce that we will, going forward, have an annual human rights disclosure report, which will seek to demonstrate, as the UN guiding principles tell us we must, what we know and show about our human rights impact. We talk about remedy and ways in which those affected by the decisions of the company can seek to achieve remedy, appeals mechanisms, and the work of the Facebook Oversight Board, which I think is going to play an important role going forward in helping to consolidate human rights standards. And our governance and accountability mechanisms, including the oversight from the board. And the last point to make, I think, because it's very relevant in this setting especially, is that in the policy we make a particular commitment to the protection of human rights defenders. There are many groups who suffer particular problems of abuse and hate speech and incitement on the platform. Women in many parts of the world, LGBTQ communities, racial and religious minorities, but human rights defenders are a particularly important group that we single out as requiring protection, and to whom we commit our efforts to try and ensure that the Facebook platforms are a place where they can operate and do their work of advocating human rights. So much more I could say, but just for now, let me leave it there. Thank you.
Thank you, Ian. And also just to remind our participants that there is a Q&A box that where you can write your questions, and we will make sure to allocate some time at the end to answer these questions. So please feel free to ask questions. And I will now narrow it down to a European context. So Louisa, I would like to ask you about what European Commission also recently adopted. It's the proposal for the Digital Service Act. Could you tell us a bit more about it? In what way this act is expected to contribute to tackling illegal hate speech at the European Union level, and how this interacts with the Code of Conduct on Countering Illegal Hate Speech that is already in place since 2016?
Thank you very much. So I mean, working on tackling illegal hate speech is something that we've been doing for a very long time. We have a framework decision on racism and xenophobia that requires all EU member states to criminalize incitement to violence and hatred based on certain protected characteristics. Now, of course, in the last few years, as was already pointed out, the situation in the online world is becoming increasingly important. And obviously, we need to complement the measures that we take to address the offenders of the online hate speech, also with actions looking at how online platforms can take responsibility for also ensuring that illegal hate speech is removed when notified to them. So since 2016, we have worked with a voluntary code of conduct together with Microsoft, Facebook, YouTube, and Twitter. These were the original signatories. And the aim of this code of conduct was to ensure removal of illegal hate speech in the majority of cases within 24 hours. A very important component was that it asks the platforms to assess notifications on illegal hate speech, not only against their terms of service, which are, of course, the own rules of engagement of the platforms, but also against the legal standard of what constitutes illegal hate speech. Because of course, from the side of the European Commission, our intention is never to ask platforms to remove any content that would be covered by the right of freedom of expression. We've had very good progress under the Code of Conduct. In the first monitoring we did, so we have a large group of civil society partners that help us to monitor the Code of Conduct. The first year, the platforms responded by removing around 28% of the content that was notified to them by these NGOs. But already a year later, this figure stabilized at around 70%, which is a number that we're quite happy about. Had there been a 100% removal rate, we would have been a little bit suspicious that platforms would directly remove without actually assessing the content, which of course would have been not at all what we want to achieve here. An area where we, the Code of Conduct has been very, very successful, and we've been joined by many other companies, including Instagram and Jeux Video and Snap and now TikTok this summer. And we believe that this is a collaborative approach that absolutely should continue. And this very much links in with a more regulatory approach that we've had in the Commission. So over the last years, we've been looking at platform responsibility in many rounds of analysis and impact assessments. And in December, we published the Digital Service Act. The aim of the Digital Service Act is, of course, first and foremost, to ensure the free supply of digital services in Europe. I mean, it's a single market, internal market instrument, but it also addresses the problem of illegal content and of the rights of users in the online world. So amongst the main features, it contains the obligation for platforms to establish a notice and action system. So as a user, you should be able to notify illegal content, but you should also have the opportunity, if you are a content provider, to protest or complain if your content is removed wrongly. What's very, very new, I think, with the code, with the DSA, is all the rules that are there to foster the rights of users. So we have a lot of rules that relates to transparency. So that the platforms should exercise diligence when they work out their terms of service, that they should provide very clear explanations to the users of the content that may and may not be posted on the platforms, that they provide data on what type of content they have removed, how much they have removed, but also that they give feedback to the ecosystem that is involved in the notice and action system. Furthermore, when it comes to very large platforms, so the one reaching 45 million users in Europe, we see that they have there's a more systemic risk for these big platforms if something goes very wrong. So for them, there are in addition a number of additional requirements where they need to put in place risk management systems and auditing and public accountability, including in relation to the effects of their policies on the rights of users and fundamental rights. There is a clear hook in the DSA, also two codes of conduct, because obviously the DSA apply to all types of illegal content. And of course, that could range from your IPR infringement to trade in extinct animals to hate speech. So the work under code of conduct of voluntary or co-regulatory approaches will continue to be very important. And we will, of course, use the momentum of the DSA to work on the code of conduct, in particular in relation to these transparency aspects that we think are very, very important from a freedom of expression point of view, and where we are really looking forward to continuing developing our policies. Thank you.
Thank you. Now I would like to ask a question to Karoline. Last week, you launched a protocol to fight illegal hate speech online. Could you tell us more about this initiative? And what, in your opinion, is the value of the EU as well as international standards recommendations for the national authorities to develop national strategies and actions?
Thank you very much. No, we can say that hate speech is very much contextual, no, in the countries and in the circumstances at some moments, no. For instance, in Spain now we have an arrival of hundreds of refugees to the Canary Islands, and this is a critical situation which raises hate speech, no, and xenophobia. So we have been working for many years in combating hate speech through the prosecutor's office, through the Ministry of Interior, through our own ministry, and we have a good collaboration, no? And a lot of things have been done. But the guidance and the instruments that provides the European Union and the European Commission are usually very useful for the countries. For instance, we have hate speech included in our penal code in Spain, following the framework decision that Louisa was mentioning before, no, on combating certain forms of expressions of racism and xenophobia by means of the criminal law. And also the code of conduct and the EU recommendation on measures to effectively tackle illegal content online have been an inspiration for this protocol. This protocol, we have been discussing on it for 2 years, which is quite a long time, and has been signed by 7 ministries in Spain: the Ministry of Interior, Justice, Education, ourselves, Interior, so sports also, equality. Also, the National Prosecutor, the Council of Judges in Spain, 6 platforms of civil society organizations, and the Spanish Association of Digital Economy, which is the umbrella association for Facebook, Google, Twitter, and many others, but the ones on social networks are included here. And the idea is to have an instrument for collaboration in how we fight hate speech. So what we have been done at the beginning was discussing the challenges of each one of the civil society when monitoring hate speech, of the institutions to fight hate speech, and also of the internet platforms. And we learned a lot from each other. And we understood also the different mechanisms to deal with hate speech. And at the end, we finalized with this document, which is some kind of the translation of the recommendation to fight hate speech online, the recommendation of the European Commission into the Spanish scenario, no? So in this document, what we agreed was, well, on combating hate speech, according to what is in the Spanish Penal Code, we established a national focal point as an interlocutor between the public administration and the platforms, which is the crime unit of the State Attorney General's office. We decided to train and provide accreditation to trusted flaggers, together the administration with the platforms. so that they learn about the norms of the platforms, but also about the Spanish legislation. No? We decided to establish procedures for quick communication for the trusted flaggers, and also homogeneous and fast tracks for reporting hate speech between the institutions, the NGOs and the platforms, and also to have some kind of monitoring and evaluation through an institutional agreement that is already working among all these ministries and platforms. We had the commissioner for justice and consumers in our presentation, and well, now we have to start working on these issues. But already has been fruitful, because, for instance, Twitter already is removing content only for Spain according to the Spanish legislation. So all the discussions that we are having, and we are doing monitoring on hate speech online daily, and we participate also as institutions, not only NGOs, but the Ministry of Interior, and we participate in the Code of Conduct from the European Commission. And this is proving also very useful, because we discuss with the platforms what we are finding in our monitoring, and well, I think it's a good way, because we are establishing a very good collaboration and some kind of relation of trust, which is very useful to improve and to find joint strategies to combat hate speech.
Thank you. And I will now ask our last speaker, Emerson. I wanted to ask that it's quite often compared, what are the differences in approach between Europe and the US when it comes to freedom of expression and tackling hate speech. So could you tell us what is your perspective in this regard, from your perspective, from your experience related to incitement in US law, the First Amendment, and the free speech? If you could share with us, perhaps you have also some thoughts after what you've heard on the experience of the European colleagues.
No, thank you so much. It's a pleasure to be with you. And yes, I'm a staff attorney now at the American Civil Liberties Union. So my work is focused around litigating cases concerning the First Amendment. So, but my background is actually in international human rights. So before coming to the ACLU, I worked all over sub-Saharan Africa on freedom of association, expression, and assembly. So it's good to be back in the international law community and seeing old friends. So I think the main thing that I think I would just cover a few quick points, and then I really look forward to hearing questions from the group. But a few points about the US approach, in particular the ACLU approach. And I think, you know, we, not surprisingly, as you said, have a quite different perspective and a different approach. The ACLU, for those who don't know, is a 101-year-old organization. We have affiliates in all 50 states throughout the United States. We have more than 2 million members. And I work in our national headquarters, where we're divided up into a variety of different themes. So we have a racial justice project. We have an international, we have an immigrants' rights project. We have an LGBT rights project. We have all these different projects. And I work on free speech. I work on the right to protest. I work on the intersection of free speech and racial justice. And I work on some issues around free speech on college campuses. So I'm happy to answer questions on any of those things. But in particular, I think, you know, it's worth just noting at the outset that when we talk about free speech in the United States, when we talk about the First Amendment, unlike international human rights documents like the ICCPR, other, you know, regional documents that talk about the rights that we all hold as individuals, the First Amendment, the first word is Congress. It says Congress shall make no law limiting the rights to freedom of belief, freedom of speech, freedom of the press, freedom of assembly. But the point is that it's about Congress. The First Amendment is about limiting government action. It's about limiting government authority to censor private speech. And so in that way, jumping ahead to some of the online speech questions, Twitter, Facebook, these private platforms have their own First Amendment rights to express themselves and to regulate their associations as they see fit. So in many ways, it's certainly an interesting free speech question. But when we're talking about Facebook, Twitter, and even other technology companies, really, it's not about the First Amendment per se most of the time, which is just an important point up front. I think the other key things to note about our approach in the United States is when the government is essentially never allowed to discriminate based on viewpoint, right? So again, we're talking about government. We're not talking about private actors or private platforms. But the government is never allowed under any circumstances to discriminate based on viewpoint. That is to say, you can never allow people to speak in favor of one thing, but not allow them to speak against it. And even when the government regulates content, so rather than viewpoint, the general issue, the government can only do that if it can satisfy strict scrutiny, right? So this is a really high bar that we set within our legal system to say that if the government wants to even regulate based on the content, not the viewpoint, but even the subject matter, they have to prove that they have a compelling state interest and that the regulation is narrowly tailored and the least restrictive means of achieving that goal, right? So that's really hard to achieve. So really what the government has to do is regulate on a content neutral basis. So we're always arguing about whether the regulation is content neutral or not. Now, the reason that this is important, I think, is because this is the reason why hate speech is not a thing within the United States legal system. There's no such category as hate speech. Why? Because hate, offensiveness, racism, bigotry, those are all viewpoints. And the government is not allowed to discriminate based on viewpoints, even if those viewpoints are widely disparaged, right? The government can speak out on its own behalf. The government can say we're against racism. The government can make rules about its own employees and how they engage with people and all those sorts of things. But the government cannot punish private speakers because it does not approve of their viewpoint, right? And so that's not 100, people say that, there's a absolutism about the First Amendment. It is robust. It is uniquely robust, I think, in the international system, but there are categories of unprotected speech, right? It's not that you can actually say anything you want at any time without any consequences, right? So there are categories of unprotected speech, but we define them quite narrowly. So the one that we're talking about today is incitement, but there's also defamation, there's fighting words, there's a handful of true threats. Harassment is a big one. So when you are harassing someone, when you are targeting them with repeated targeted words that are meant to inspire fear, that's harassment and that's unprotected speech, right? Obviously, violent action is unprotected by the First Amendment, but we define these categories very narrowly. So in terms of incitement in particular, we have a very strict test. It's called the Brandenburg test. It was established by an ACLU case. Notably, we were representing members of the KKK in that case. One of the lead attorneys was Eleanor Holmes Norton, who was a young Black woman attorney who now is in Congress, pushing right now for DC to become the 51st state. But I spoke to her about what it was like to be on this case, and she said this was an absolutely critically important case. And it established the rule that you can only be convicted of incitement. You can only criminalize speech as incitement in the United States if it satisfies three standards. It has to be intentional. It has to be likely that there will be imminent unlawful activity, and that is objectively likely to occur. Sorry, it has to be intentional. It has to be likely, and it has to be imminent. That is to say, for you to hold someone responsible for their words that affected someone else's actions, basically we're worried about any time you're going to hold one person responsible for the unlawful activities of somebody else, right? We want to be very skeptical of any government's attempt to say, oh, you agree with them and therefore you're responsible for what they did. Now, if someone does something unlawful, of course they can be held responsible for that. And when they are working in concert, when they are, a part of the same scheme, you know, that can be punished. But what we're really worried about is the idea that expressing unpopular views, and even if some other people who share those views do something unlawful, tying those two things together, right? And so the Brandenburg Standard was used to protect the KKK meeting. So they filmed the KKK meeting off in a barn somewhere, right? And so the idea was the Supreme Court said, as horrible as what they're saying is, they were off in a barn by themselves. They were not about to do anything, right? There was no incitement to do anything. They were just out there being foolish, right? But we've applied that case, controversial as it may be, to defend the KKK's right to make racist videos. We've applied that case to defend the NAACP and Claiborne, in the landmark Claiborne case, where basically the government was trying to go after NAACP organizers for using fiery rhetoric and saying that they were responsible for violence that happened, that they did not directly authorize. And so that standard, again, we used most recently in a Supreme Court case around a Black Lives Matter activist named DeRay McKesson, where a police officer tried to sue him to hold him responsible for someone else who he didn't know, he didn't identify, he didn't authorize. Someone else at a protest threw a rock and hit a police officer, and they wanted to hold DeRay McKesson liable vicariously. And again, we referred to the Brandenburg Standard and we said, look, you cannot hold somebody liable for the actions of somebody else if it was not intentional, likely, and imminent that their words were going to cause this unlawful action.
Thank you so much. I would like to again encourage everyone to write your questions if you have any. And now I will follow up with this question about challenges, because we've just discussed some of the initiatives, some of them new, some of them already older, let's say, different approaches. And there is this never-ending question, how to balance the right to freedom of expression and how to tackle hate speech effectively. So I would like to ask you, like, what kind of challenges do you see in the future in your work in this regard? So perhaps I would start with Ian.
Thank you. Thanks so much. And thanks to the other panelists for really, really interesting interventions. I mean, the challenges are huge, and some of them have been touched on in other interventions, but just to maybe try and capture 3 or 4 of the most critical. I mean, the first, as I said at the beginning, is just the scale and the speed at which these issues are playing out. I mean, we have something like on Facebook 1.73 billion users on a daily basis. Now, obviously, the vast majority of them are not posting hate speech or incitement to violence or discrimination or other kinds of hostility, but just the scale of the global participation in social media platforms, I think, creates unprecedented challenges for all of us, for human rights organizations, for groups like the ACLU, for governments, for regional intergovernmental organizations like the EU or the UN. These are really unprecedented challenges. I mean, the second challenge, is as we talked about, the contested definition of hate speech. I mean, I was fascinated to hear Emerson's description of the Brandenburg Principles. Really, really interesting. At Facebook, we work with the Rabat Principles, which is a similar test, a 6-part test in essence, which tries to establish a threshold for what constitutes hate speech and how we navigate this extraordinarily complex sort of space between hate speech and free speech. And in the Rabat Principles, I mean, they're very similar in many ways to the Brandenburg ones, but we look at context, the speaker, the intent, the content of what they say, the extent of it. Is it something that is spreading far and wide? Is it coming from someone who has massive reach? And the likelihood of harm. So quite a lot of overlap with what you were saying, Emerson. But there are differences, and particularly for a platform operating in so many different countries around the world, trying to establish share definitions across dramatically different contexts. You know, if you think about what does incitement to violence mean today in Ethiopia, in the Tigray region of Ethiopia, beset by tremendous and violent conflict, as against incitement against refugees in Spain or whatever it may be, obviously enormous challenges. And the last point to make, and I could make lots of others, but just one more I do want to touch on, given some of the things we've talked about, is government regulation. There is unquestionably, you know, a demand from lots of different sectors for this smart mix between self-regulation and government regulation. And certainly we, in establishing a human rights policy, are not in any way suggesting it's a substitute for government actions, but we are seeing around the world, in many parts of the world, governments looking at social media platforms as, in some cases, the last bastion of dissent, the last bastion of protest, the last bastion of pushback against government authoritarianism. And they are seeking to make social media platforms complicit in repression of freedom of speech. The critical challenge for all of us, you know, NGO, UN, government, social media platforms, to put human rights at the center of this debate and ensure that we use human rights as a universal framework for the protection of users, particularly the most disadvantaged, racial and religious minorities, human rights defenders, women, LGBTQ communities, and others, I think is really something we see as one of the central challenges of our time in protecting rights in the digital space, and one that will not, a battle that will not be won without tremendous engagement with key stakeholders and users, and the key actors coming together around a shared set of values and principles.
Thank you, and especially for mentioning the Rabat Plan of Action, because our organization was one of those who helped to develop it, and we are advocating for the use of it. I totally agree with you on this. So I would like to now ask the same question, Louisa. What kind of challenges in your work at the European Commission you see in the future in implementing the plans?
Well, I think working in this field as a regulator is always a challenge, for the very simple reason, I mean, Emerson mentioned it, it's got to do with who is actually bound by human rights standards or not. I mean, at the end of the day, platforms are private companies, so, you know, they exercise their own decision in terms of the content that they want to have hosted. And I mean, it's not for the state to interfere in this freedom of contract either between the platform and the users, where they establish their business model. At the same time, from the regulator side, we of course have to take action to ensure that content that is illegal is removed. But it's much more difficult for us to make a platform keep content up that falls within the right to freedom of expression, because this is, of course, regulated by their content moderation. So this is the very, very delicate situation the regulator finds itself in, because we can push platforms or the industry towards removal, but it's very difficult to crawl back from that. So when we formulate our policy responses, we have to be very, very cautious about what the actual consequence will be. If we, for instance, impose obligations to use automatized tools for detection of illegal content, which I think is actually nowadays the most common way of removing, I mean, I think around 80 or 90% of all content is actually removed by these automatized means. But if we were to put in place that type of tools as an obligation, we would have to look at how would this play out in reality. Would all the platforms have the human resources, for instance, that would be needed to verify that all the content caught by these systems is actually legal? Are these type of tools relevant for all types of illegal content? Maybe it works very well for well-known sexual abuse pictures of children, where you have a static picture, but it's much more difficult to apply in a context dense area such as illegal hate speech. So as the regulator, we have to do very, very careful impact assessment to see what the likely outcome of the measures that we take will get at the end of the day. I think another challenge is exactly, and I mean, Karoline also mentioned it, I mean, this necessity of bringing the actors together, bringing the civil society partners that exactly have this very, very precious knowledge of this contextual, historical, and linguistic specificities of hate speech in that particular context. And that knowledge needs to be brought together with the platforms and their content moderation teams. And that is something that we have worked a lot with under the Code of Conduct, and where we see that we're really having good exchanges in terms of, to the extent possible, ensure the best possible standards for content moderation. There will always be mistakes, of course, but we should have as good standards as we humanly can achieve. Then I think the last and maybe biggest challenge is the speech that is protected. It's not illegal, but still very, very harmful for society in terms of spreading stereotypical or we and them type of narratives that polarizes our societies. And of course, we can't address this type of speech by removing it. We have to find other ways of addressing it. And I think that's a real challenge, how we do that, that unfortunately I can't give you the answer to.
Yes, thank you. That's true that the states are also obliged to introduce some, as we call it, positive policy measures, because obviously removing the content itself doesn't solve the problem of prejudice and intolerance in the society. So I'm with you on that, and that's one of the biggest challenges indeed. Karoline, can I ask you the same question now about the challenges for the future?
Well, it's not an easy question. No? The balance between hate speech and freedom of expression, I think is really difficult. No? And we see that also in our country, how difficult it is also for judges and for prosecutors to penalize this question, because they, as they are crimes, the penalty is quite high, no? And they have always to balance very well what they do. But I think Ian said something which is important when analyzing this, which is putting human rights at the center and the dignity of the person at the center of the question. Because really hate speech is very, very harmful for the person and also for the society as a whole. And some of the characteristics as the context and the extent, I think they are very important to analyze hate speech. And in that, I think we need also international collaboration, because we have many circumstances when a prosecutor is asking, well, a company which is based in the United States for information regarding hate speech content that in Spain is a crime. And we don't get this information because in the United States is protected, no? So this is also a difficult question. And we think that the collaboration between all the actors is very important in this aspect, no? And what Louisa was saying, legislation is very important, but we need also other tools, no? Other tools as education, as improvement of reporting, analyzing the data to see what the scenario is. Also raising awareness among politicians and among the media, because when we work with the media, raising awareness, the news that they deliver are less racist or less Islamophobic, so they can do it much better, no? And hate speech is, well, the number of users is so huge that we need also other strategies. I think only with penal legislation is difficult to control this, because there is a lot of very harmful speech which is not a crime, no? But it's also producing a lot of instability in the society and harm in society. So, well, hate speech per se is a big challenge, I think.
Thank you. And Emerson, can I ask you the same question?
Sure. No, I mean, I echo all of the challenges that my co-panelists raised. I mean, I think some of the things that we're thinking about at the ACLU at the moment is getting a little bit beyond the sort of, do we like it? Do we not like it? Do we want it online? Do we not want it online? I mean, we're starting to get into like the nitty gritty of what does it mean? Who are we talking about in terms of, you know, so often when we're talking about online speech, we're really talking about speech on the big four platforms, right? Like, or in these big, massive platforms. But it's a very different set of considerations when you think about much smaller communities online, what kind of regulation you'd want to have in place for those. And so just thinking, you know, we're not talking about all technology companies when we think about the power of big tech to regulate speech or the spread of speech online. But at the same time, these relatively unknown platforms can be hugely influential as well. So I think just sort of getting some nuance into who we're thinking about in terms of on the private side, but also who do we want to have the authority to respond? I mean, we heard about an interesting model of sort of reporting in the European context. But I think, you know, when we think about, you know, the implications of removing someone from a particular platform, like, you know, banning somebody from Twitter for doing something that was offensive, it feels very different to us than, you know, getting closer to the internet infrastructure, right? Like banning someone once you start pulling out IP addresses, or, you know, the sort of internet service providers then withdraw their support for certain, you know, kinds of speech. That becomes a little bit more complicated, right? Like Twitter clearly has its own First Amendment rights, but do we really want it to be the case that, you know, people with abhorrent views do not have access, cannot even get internet service? That seems to be a much bigger sort of human rights issue on both sides. And then I think the other thing that we are thinking a lot about is the intersection between not just, you know, hate speech. Obviously, we are against all of these things. We have, as I said, the women's rights team, the LGBT rights, Racial Justice Project. The ACLU is fighting on all of these fronts against hatred, against racism, against bigotry. So I think our position on all of those things is obviously absolutely clear. The question is, how do we regulate speech in a way that doesn't have negative consequences for the kinds of speech that we also agree with? Like, we just want to make sure that the rules that are in place don't end up you know, squelching the opportunity for social movements to flourish. So I think, you know, we're worried about that, but we're also worried about the intersection of speech and privacy, especially online. and the use of surveillance. And here again, it gets into nitty-gritty far beyond my expertise around the technology. For example, even if we're talking about illegal content, who removes it and how, and using what mechanisms, right? Like, is it the government that removes content? Is it the platform? And, you know, does that mean that they're then collecting? What kind of information do you need to collect in order to figure out what information needs to be removed, right? And so we're trying to make sure that in our effort to squelch out this horrible content online, we don't end up sort of losing track of our privacy interests as well. And I think, you know, trying to get courts, which are mostly populated by, you know, folks who are not digital natives, as they say, to understand sort of where we should be drawing the lines around privacy and speech online is a huge challenge. And we are constantly trying to figure out where we want to draw the lines, never mind where we can get courts to draw them.
Thank you very much. We have only a few minutes left, and we got one comment and one question. So I will start with a question. With respect to the balance between freedom of expression and freedom of religion, with respect to criticism of Islam and of Muslims, could you describe the difference of approaches in Europe and in the US? So I don't know if any of you would like to take this question, but quickly, as we have just a few minutes left. It's a big question, so not easy to answer quickly, but perhaps we could try.
I can say in the US, I mean, freedom of religion in the United States is actually another very interesting right that is now threatening to eat up a lot of other rights, including the equal protection. Basically, the main issue right now around freedom of religion in the US, and I'm sorry, this is not exactly about discriminating against Muslims, but the way that freedom of religion is mostly playing out now is about the freedom to discriminate, right? And so private folks basing their First Amendment right to discriminate based on viewpoint in their own religious belief, which is super important. But in general, we have really robust freedom of religion protections and free speech protection. So criticism of Muslims as a general principle cannot be regulated by the government. It can be, you know, responded to by other private citizens, but it can't be regulated by the government unless and until it goes into the areas of harassment, threats, or actual violence.
There, at the European level, the situation is, I mean, you obviously have all the rights in the world to criticize religion, including Islam, Christianity, or Judaism. But what you cannot do is to incite to violence and hatred against persons or group, or persons perceived to belong to that group. So, I mean, that's the difference here. But criticizing religion and falls squarely within the right to freedom of expression. And we have a long jurisprudence of the European Court of Human Rights on these issues.
Mm-hmm. Thank you very much. It's such an amazing discussion, and we could go on like this for hours, I'm sure. But unfortunately, we need to wrap up. So I just wanted to say at the end that obviously the internet has brought new challenges, and there are still new challenges to all of us, and the proliferation of hate speech and harassment targeting marginalized groups and human rights defenders, disinformation intended to undermine public debate and trust, incitement to terrorist acts are among those with significant and negative human rights impacts. And these trends pose significant challenges, and we talked a lot about challenges today, to the often repeated maxim that the same human rights people have offline must also be protected online. So I guess that our aim is to work into this direction in the future. So thank you very much for the discussion and for your insights. And now I will turn to Christie, who wants to say a few words at the end.
Just add my brief thanks to all of you for joining us today, to the panelists for your incredible remarks. We've all learned so much, and hopefully within ODIHR and of course within ACIL, we'll continue having these conversations, which are of course very interesting and very timely. And so we're thrilled that you all could join us today. So thanks so much, and look forward to chatting with you all soon.
Thank you very much.
Thanks.
Thanks so much.